Hello, everyone. I'm Alonzo Martinez, Associate General Counsel at HireRight, and joining me today is my friend, Caroline Smith, HireRight's Vice President and Deputy Counsel. And this is compliance considerations for building a global screening policy. While Caroline and I are lawyers, today's webinar is not intended as legal or compliance advice. Our intentions are to give you information that you'll take as talking points to raise with your teams and your legal counsel. Before we begin, as always, I want to cover a few housekeeping items. During this webinar, please take the conversation to Twitter or X using the hashtag HireRightWebinar. We are not providing copies of today's slides. However, we will send you an email with a link to a recording of this webinar session. If you are experiencing any audio or video problems, please refresh the browser window by clicking F5 on your keyboard or send us a message using the Q&A icon at the bottom of your screen. Doreen is producing today's webinar and will be monitoring the feed for any technical issues. And after the presentation, we would appreciate getting your feedback. So please take our brief survey and let us know if this session was helpful. And again, press F5 on your keyboard to refresh this presentation anytime you experience any audio or video problems. So let's dive in. Global screening policies. For me, drafting a global background screening policy, it's a lot like playing a game of Tetris. I think Tetris is something that is a global game that we can all get behind. Think about Tetris. Just as each Tetris piece has to be rotated carefully to fit seamlessly into that growing structure, each element of a policy has to be crafted meticulously and has to be aligned to accommodate many things. Think about the diverse legal and cultural landscape of different countries. Caroline and I have spoken about this extensively. And think about Tetris. What happens when you place a piece in a kind of funny way? A poorly placed piece, it can create these gaps on the board that make it harder to progress. In the same respect, an inadequately considered policy component that can lead to compliance issues and inefficiencies from an operating standpoint. So the challenge, just like in Tetris or building a screening policy, is to maintain this kind of fluid and adaptable strategy, adjusting continuously to the new shapes that are coming down the board, the new constraints, while keeping that overall objective in mind, a coherent, robust system that withstands the test of time and ultimately presents like a willing policy for you and your organization. So let's jump right into it. Our foundational question, Caroline, what do you think about this? What is a policy? What is the policy's purpose? What is the policy's purpose with respect to a global screening policy?
So I think when you're looking at rolling out your sort of policy or looking at the policy's purpose, you're really trying to build or create a document that allows you to articulate why you're actually doing any screening. And so you're wanting to always start at a really consistent basis across the globe. And then trying to really delve further, as you say, kind of put all those building blocks down, those Tetris blocks down, to kind of look at how you might want to localize your policies. Because ultimately, not having a policy means that it might be a little bit more difficult to get internal buy-in from your teams, because not all countries are aware of what screening is. And there may be some resistance internally within your local teams. So you need a document that will communicate why you're screening. But also as well, at the end of all of this, there's actual candidates that are coming through all of these systems and being screened. And having a policy and something that perhaps you could derive from that policy that you then disclose to your candidates, again, allows that candidate to understand why screening is occurring, and removes all of that friction. So it's your first building block of your communication out to your teams and to your candidates. So it's super important. I mean, what's your view on that one?
I agree completely. I think when we're talking about actual policy construction, right, we're going to talk about this as we go through today's conversation. The point is to keep the policy simple. And a programming note. When we're talking about policy, Carol and I will be talking a little bit about policy, but also process. Recognize that policy is exactly what Caroline is talking about. It's building this consistent and comprehensive framework for conducting background checks on your group of covered individuals, whether that be prospective employees or non-employees, for your global organization. You want to create this policy that ensures integrity, safety, security of your workforce. So your policy statement is probably something as simple as answering the question. The purpose of this global background screening policy is to do X, to establish a consistent and comprehensive framework for conducting background checks on prospective employees, for example, across our international organizations. I think that that's a fair opening statement to the policy. What are your thoughts, Caroline?
Yeah, absolutely. And like I said, that fairness and that communication out to your teams and your candidates is really the foundation of how you'll get a successful programming. One of the things that we hear consistently in our roles as lawyers within this organization is, well, how do I get buy-in? How do I get people to understand what I'm doing? And that is essentially what the policy is there for. So yeah, defining those objectives, being consistent with those objectives globally is truly key. But then, and as we'll explore this as we go along further within this webinar, is like really considering that localization. So you're still linking your localization and taking any localization considerations or requests into account, but always pinning them back to your objectives and that consistent approach. And as I say, that should remove your friction when you're rolling out that policy.
Can you talk a little bit more about friction? Because I know that this was a point that was important for you, the purpose of building a policy as towards eliminating friction. Can you expand on that?
Yeah, so, one of the things, in the US, anybody that's on this webinar that's in the US, you're very familiar with background screening. It's something that's been done for years and years, and it's an industry that's grown. In the UK, where I'm based, it's certainly a growing industry, and we have a lot of uptake for things like screening, particularly in industries like financial services. But outside of the UK, in mainland Europe and perhaps in APAC as well, screening is not particularly adopted. And that means with both people who are moving roles, they might not ever have been screened before, so they're sort of like, what is this? But also where you have, local HR teams, they're not used to having to go through or administer a process like this. And so where people aren't used to things, you have to go through some form of change management to get your internal teams buy-in. And so that you can roll out your policy, you can manage the risk within your workforce against your objectives consistently. And also so that those candidates that then come through really understand why you're doing the screening. And again, one of the recommendations that we would always sort of, be big proponents of is having a sort of summary of what your policy is that is communicable to those candidates as they're going through that recruitment process. So they're not blindsided by all of this. And again, they can get on board with the reasons why you're screening. That just removes all of that friction and that sort of like relief from somebody saying, hey, I've got a job, yay. And then suddenly going, oh no, I've got to fill in yet more forms and go through more processes. And it can feel like a barrier. As soon as you remove that friction, it's just something like, okay, yeah, fine, I've got to go through this. I understand why. I'm not going to raise questions.
You'll hear Caroline and I talk a lot about transparency throughout today's presentation, but we're talking about candidates. Why should we screen? What do you think, Caroline?
Oh, there's just so many reasons why you should screen, including because it's just the greatest thing ever. But screening obviously developed, through certain industries in the US in terms of, sort of the trucking industry, et cetera. So, things like, driver license checks and drug and health screening are sort of no-brainers. It's just ensuring that people, aren't doing things that are going to cause you risk within your business. So risk mitigation is obviously going to be always your sort of first port of call. But I think increasingly, and you've also got certain regulatory requirements in some industries. But I think increasingly what we are seeing is that sort of employers are and candidates are really responding to and wanting to work in organisations that really are looking at safety in the workplace, purpose in your workplace, and promoting a good environment where everybody can thrive. And that's another reason, it's maybe not a traditional reason why people might consider screening, but it's certainly something that we're seeing, increasing, that this idea of a screening program that effectively helps your hiring decisions, which in turn then promotes a really great work culture for all of those people that are going to be joining you.
Yeah, I agree. I think that your policy statement, again, so for our audience, when Caroline and I were putting together today's presentation, we were thinking about answering a series of questions. How would you build a policy through kind of asking yourself, what are you trying to accomplish? And your second question as to what you're trying to accomplish is exactly what we're discussing. Why are you screening? So your answer to that question is really what drives your policy. A statement like, we are conducting background screening to uphold the highest standards of trust, to include workplace safety and integration and integrity within our organization. That is really the answer to your policy statement here. Of course, like Caroline mentioned, you have to consider localization and a global aspect to this. In the US, like Caroline mentioned, we have very regulated roles, which in many cases may dictate the process for screening: transportation, healthcare, finance, for example. But otherwise, the flexibility behind screening is far more open. We talk a little bit about protecting the company's reputation, and I think that that's something that we can get behind globally. In today's day and age, with news, and I'm putting news in air quotes, spreading like wildfire through platforms, social media platforms, it's really important to understand who is within your organization, and how you're protecting your organization's brand reputation. And screening can certainly be used for that particular purpose. Like we say on the screen here, knowing why you are screening helps to define your program. And that's exactly what we're going to talk a little bit about next. So Caroline, who does the policy apply to? Who should we be screening?
Yeah, and again, I think this considering who you're going to apply your screening policy to. Again, it's that next stage. Once you know who you want to apply the policy to, what roles you have in your organization, and where you think any, you go back to your first question, why am I screening? So if you're only doing that for risk management purposes, you would then want to look at your candidate, your role populace, and kind of say, okay, well, which of these roles actually carry those risks that I'm trying to protect? So I'll screen these guys. So again, it all feeds into the idea of transparency and communication, and making your policy and the reasons why you're screening a little bit more robust and understandable by local teams and also the candidates that come through. But the other reason why asking yourself who does the policy apply to is super important is because once you get to that stage of trying to define what you're actually going to include within your screening program, it allows you to actually look at all of those local laws that Alonzo and I have alluded to allow you to then figure out what checks you're going to do. Because again, even if you've got a role that's consistent across all your various geographies, it doesn't necessarily always translate that you would run the same checks because of different local laws. So again, it really helps you, that really basic question of who am I going to screen, so who does the policy apply to, will really then help you build the rest of your program off the back of your policy.
So Caroline, we have a question coming in, and thank you, audience, for engaging with us. We would love to have more questions from you. This is your webinar. We have a question about screening or policies specifically for part-time, non-essential employees and for minors. Should those be separate policies? How do we address our different types of workers within our organization?
Yeah, I mean, I think this comes back to the exact question we're asking. It's like, who does the policy apply to? And it's that balance between consistent approaches globally, or consistent approaches, generally, versus your populace. So there's a number of ways that you can do. You can have one policy that has different parts in it that addresses who the different roles are and what those, what the different screening programs are. Or yes, you can have different policies in place. It really depends on how your organization is structured and how best to administer the policy. Because what you don't want with any policy is to have something that's so complex to administer it becomes confusing for those who are having to actually implement it. So it really is a bit of a balance. And I don't think there's a right or a wrong way to tackle those different things. I think it's it goes back to these fundamental questions. If you know who the screening policy is going to apply to, and that included, for example, minors or part-time or non-essential workers, when we get onto the other questions that you have to ask, that's when you can start to see where you pass those out of your generic overarching, this is what we're going to do. You can do it all on an exceptions basis, except for these guys where we do this.
I agree with that. And I think that you really keyed into something that is important, which is making the policy as simple as possible for your workers. To that end, I think that the individual is actually responsible for administering the processes for that policy, that you could consider separate process documents for each of these different employee types, because how you screen executives, for example, is going to be very different from how you screen temporary or contract workers. Probably true. So you would probably want different process documents that outline, we're going to talk about this in a bit, the scope of screening, what you're actually searching for, and how you actually would adjudicate those particular checks based on those various employee populations. One thing that I did want to note, just to get into a little bit of the nuances of the law, here in the United States, many of you may be aware that the Fair Credit Reporting Act, this is the regulation that's responsible for regulating how you as employers would request background checks and how we HireRight as term of art in the United States, a consumer reporting agency would provide that background check to you. It has broadly defined the scope of individuals eligible for screening. Basically, the scope of what we call the employment permissible purpose is really large. The Federal Trade Commission, one of the regulators here in the United States, has opined that various type of workers, including non-traditional workers or non-employees, can be included within that scope of screening. So you might want to consider this as you're building your process. Consider how the law applies and who can actually be eligible for that purpose within the United States as well as separately globally. So Caroline, let's talk a little bit about authorization. How will an organization, how will an employer obtain that written authorization for the check? What are your thoughts here?
Yeah, so just sort of tapping into sort of what Alonzo just talked about there with your permissible purpose, talking for outside of the United States, what we're always looking at is the principles under our privacy laws, and the principles are very similar whether you're in mainland Europe or whether you're in APAC. And what you're always looking at is fully informing an individual as to why you're doing something, hence why these initial building block questions are so important. So in terms of obtaining that written authorization, you've really got to plug back into the whys and wherefores. So explaining to somebody why I'm doing something, and then, how's that data going to be used? What rights do they have in relation to that data, and communicating again sort of what checks you're actually going to run. And in terms of that written authorization, there's again multiple ways that you can do it, but you do have to have evidence that you have, informed this individual. So working with a provider that has a system in place that can capture an information notice where somebody clicks on, that's fully auditable, again, is a really important part of any policy and process. That auditable, I've informed somebody what's going on, and then capturing any written signatures that you need for that authorization. You can do that outside of a system and then upload it later or otherwise, but having it within a system, again, that again you can download documents from, is a really important piece. Authorizations, I know, in the United States are a little bit different to those in the EU, for example. So Alonzo, how would that differ in the US?
Yeah, so that's right. So in the US, we have a very prescriptive process for disclosures and authorizations. So again, I talked about the Fair Credit Reporting Act. The Fair Credit Reporting Act requires that before an organization requests a background check from an organization like HireRight, that they provide a disclosure to the individual. it's really interesting because the form of the disclosure, what actually is disclosed to the individual, that isn't actually dictated by the Fair Credit Reporting Act. Instead, that's been defined by case law. What we know is that there should be a standalone disclosure, so separate, for example, from an employment application. The document should consist, quote unquote, solely of the disclosure of the background check. But again, the regulation doesn't actually tell us what solely the disclosure of the background check is. Case law tells us that it needs to be as simple as possible. It also, like I mentioned, needs to be a standalone document. It needs to be free of extraneous information. So the disclosure really needs to relate to the background check itself. It needs to say something like, I am requesting a background check for this particular purpose, and not much more than that. Um, the authorization can be included within that disclosure. It can be separate. From a HireRight perspective, like Caroline was mentioning, we offer an electronic consent process through our platform. Generally, that disclosure is provided as part of the tail end of the background check process, which differs a little bit from how the platform handles notices and disclosures on outside of the United States and the rest of the world. Caroline, you can touch on that in a second. But effectively, the candidate provides that disclosure, or is provided that disclosure. They provide their authorization via the platform, and then the background check kicks off. Separately, employers can provide those disclosures and authorizations outside of our platform, and you would want to retain those. But again, the most important thing is that before requesting a background check, you have provided that disclosure and you have received that authorization. Note that in the United States, the concept of ongoing authorization, ongoing disclosures and authorizations is unclear in some states, particularly California. Therefore, every time you screen, you may need to provide a disclosure and receive that authorization. Caroline, do you want to talk a little bit about the specifics of the processes outside of the United States with respect to notice, disclosure, and authorization?
Yeah, so what our legislation says is that you have to have a lawful ground of processing, and you have to fully inform an individual as to what that lawful ground is and what you're going to be doing with that data. So there's certain key points, sort of confirming that, there's technical security measures, what, as I mentioned, candidates' rights are, who has access to that data, is there going to be any data transfers, and all of those things need to be included in an information notice. Now, the timing of that information notice should always be before you process data, and it should also be before you capture any consent. So the way in a platform such as HireRight, the way that works is that the information notice is actually put up front before any data is actually collected. And again, one of the reasons that's important to do, and again, why a policy is actually to back this up is really important, and to get that policy in front of candidates as they go through your interview process, is that removal of friction. So the more that you can explain to the individual about what's going to happen to them, what type of data you're going to collect, the more likely it is that individual will they'll enter into a platform such as HireRight and give you all the data that you're actually requesting, because they understand the reason why. And really the sort of European legislation and all of the legislation in APAC and Latin America that has followed is all about putting the individual front and central and in control of their data, so that they can make choices about what they want to do. So once that individual's then been informed, provided all that information, you then have to get some sort of authorization or acknowledgement. Now, how that's actually drafted will actually depend on what lawful ground of processing you might have actually chosen. So you can, some customers still rely on consents. So it might be drafted in a kind of consensual language. In other instances, you might be referring to something, you might be relying on something that we refer to as legitimate interest, which is where you've balanced your right to find out information against somebody's right to privacy. That's going to be drafted more as an acknowledgement, or in certain regulated industries, there may be a legal or public policy ground for which you're relying. And again, your acknowledgement, it would be more of an acknowledgement, but acknowledging the ground of processing, what's occurring, and providing that signature. Now, one thing that I think is really important outside of whatever ground of processing you ultimately choose outside of the US, is that you're still always going to have to capture a signature, because sources still require, in many cases, signatures, and in some cases they still require consent. So there's an opportunity to add on consents. So that's generally sort of what will occur, and the drafting of that initial information notice and the provision of that information is one of the most critical parts of making any background screening program and policy work. And that there are some outliers. So, for example, in Russia, that has really strong data localization laws. You may have to, depending on how you're initiating those checks. So, if, for example, you're initiating those checks directly from your Russian entity, for example, you may have to get an authorization up front, so a pre-authorization to allow you to share the data with the third party before that candidate sees another authorization within our system that talks about the actual background screening, because there's as I say, you have to have a primary database in that location. And you can transfer the data, but only on an authorization of an individual. So there are some regional complexities, but again, that's why it's so important to have these policies in place to identify the jurisdictions you're screening in and what some of those peculiarities might be.
So let's keep things moving and talk about the types, the scope of screening, the searches and the verifications that'll be requested. How do we address this in our policy, Caroline?
So again, you've got your building blocks. So you've established why you are actually doing your screening. So what's the purpose of it? That will help you outside of the US. It will help you determine what lawful ground of processing you're going to be relying on, which can in some cases dictate what kind of check you're going to do. And you're then looking at your candidate pool. So what roles are you hiring for? What level of risk do those roles carry? What information, for example, can they access within the system? And then in what countries am I rolling out my program? And all of those four foundational questions that you've sort of outlined in your policy then help you figure out what kind of information or checks you're going to run. So there's a variety of checks that can be run: criminal checks, credit checks, employment, education checks, sanctions checks, all sorts of different things. But those four questions effectively will allow you to choose what type of check you then run, because for outside of the United States, we always have to go back to again, privacy principles around what's relevant, what's proportionate when I'm processing any data. And overlaid on top of that, we sometimes have some local laws in country that will not permit us to run certain checks, for example, Poland criminal checks, unless it's for a very specific regulated role in the financial services industry. So it's your foundational questions that allow you to then look at the suite of products and then align those products to the jurisdictions and your roles to build this nuanced program that addresses your underlying purpose for screening. And in the US, Alonzo, is that the same kind of consideration?
It is, Caroline, actually. So it's interesting because there is certainly overlap in the United States at the state and local levels, in particular with things like credit screening, for example. And an employer could not request credit reports on all workers in certain states, California, Colorado, for example. Additionally, there are additional requirements that may be placed upon an employer who does request credit. So, for example, in California, an individual who is in a managerial role has access to a company's confidential information, may handle money. Those individuals are eligible for credit searches, but there are notice requirements that would have to be provided to the applicant prior to requesting that particular credit search. So there are very nuanced processes that you would want to build into your process document that accompanies your policy with respect to the types of searches or verifications that you'll request. Similarly, in the United States, for example, there are limitations on requesting things like sex offender registry searches in California and the state of Nevada, for example. An employer is limited on the information that it can utilize as a result of certain laws within those states from sex offender registry searches. So these very nuanced things are very important as you build your policies and your processes. Caroline, I think this is an interesting question from our audience. We have an individual that says that they worry about accusations of discrimination if policies are different, specific to the types of searches that are searched or the types of workers that are subject to a background screening policy. How can an employer address accusations of discrimination as a result of differences in their policy? Your thoughts?
Yeah, so I think that's why we always say start at that question as to why am I running these checks? That should be consistent, across your entire organization, across all roles. There's a reason why you want to run these checks. So that's consistent. And then, as we say, you start to dive down into various roles and into various jurisdictions. Inevitably, you are always going to have some differences. So it's really about when you're building your policy, it's keeping that audit trail of your decisions. So if you decide, for example, that I'm going to run a credit check on this particular role type in this jurisdiction, keep a table of that sits behind your policy as your decision making with the reason why you're doing that. Now, it doesn't mean that people aren't necessarily going to challenge that or have allegations of sort of discrimination or you shouldn't be running that. But your first line of defense is always your policy and what sits behind that policy and your decision making. So provided you can show that you actually went through a process to consider, was this relevant? Was it proportionate? Should I be doing this for this role? Does this country allow me to access this source or run this particular check for this type of role? Provided you've asked yourself those questions, essentially it's difficult to then challenge the sort of logic or the reasoning behind why you're doing something. But again, I mentioned it in the sort of, how do you get your authorizations? One of the key things that you have to have in your information notices and remind individuals of is their rights. So their rights, one of the rights is to, in sort of non-US world, is to be able to have a copy of your report, but also to challenge anything that's in that report. So basically ask for a right to rectify any data. So what we would always say is, as part of your policy and to really stop discrimination claims is you need to build something into that policy that effectively says, okay, if I get a discrepancy through or an adverse record, I don't just necessarily always, just kind of say, right, that person's not to hire. You would have a dialogue with that individual, have that discussion, what occurred, what does this mean, and allow them to provide extra information potentially. So there's lots of different ways that you can actually fend off that discrimination. But the fundamental is going through that whole process and having your auditable trail as to why you've decided to run a particular check for that particular cohort.
So one more question from our audience before we move on, because I think that this one's particularly relevant and something that I hear from employers a lot. An individual asks, how would you advise confirming legal law in certain regions? This organization is based in the UK, but has individuals working for them in the Nordics, Central Europe. They often hear conflicting information as to what is legal and what is not, something that we hear from our clients a lot. How do we determine where do we go?
Yeah, so I think sometimes in certain countries, and I think the Nordics is one of the regions actually within Europe. It's actually the laws on what actually happens don't always align. So to give an example, in Sweden, there's some, in terms of running a criminal check, you should only run a criminal check in certain circumstances. There's some underlying laws that allow you to run criminal checks in certain circumstances. But you can actually also ask an individual to self-disclose. And one of the ways that you do that is that individual will go and get their own criminal record certificate. So you kind of put it in their hands. And that's something that happens quite a lot in Sweden and in many of the Nordic countries, is that you put that question in somebody's hands and they determine whether or not they want to fulfill your request of self-disclosure. What you have to make sure then, of course, is that you don't discriminate if they don't disclose to you. But really, it's about, I think, if you're going to sort of try and figure all of this out, and it is a bit of a spider's web, a bit of a tapestry, it's start off with principles. What's fair and what's reasonable and what's proportionate. So always start there, because that's your privacy law, and we're effectively processing data. So is it fair, relevant, proportionate to do so? then look at where's that person actually going to be employed. So they might be living and working in a particular jurisdiction, but they might be under a UK employment contract. So always look at the employment contract laws, because that will be where you'll find those esoteric differences that might make you go, okay, well, I think this is relevant and proportionate, but actually this employment law says I can't run this type of check, or I should only run it in this part. So always start with the principle, then look at the employment law, the contract under which that individual is actually employed under. But it is really tough. And like I say, a lot of this comes down to your policy and justifying why you're running these checks. And somebody challenges it, listen to that challenge, and you might need to change your policy.
So as we're about halfway through today's webinar, let's talk about timing. When will we request these background checks? Caroline, your thoughts on the policy?
Yeah, so I wish we could say you can just request, the checks on day 37 of talking to an individual, and then you're fine. Unfortunately, much like with all the rest of this, when you do the checks can be dependent on a number of factors, and that can be whether or not, which jurisdiction you're particularly screening in, what ground of processing you're using. Again, when you are building your policy, you're constantly referring back to the questions you asked yourself previously. So by the time you get to this question, you've got a framework of why I'm doing this, what ground of processing what grounds am I relying upon? Who am I actually going to be including within my cohort of folk that I'm screening? And what is it? Where are they? And what is it that I'm going to screen? All of those things together will then help you determine the timing of those requests. But
there are some questions. Yeah, and there are some questions, Caroline, about how often an individual can be screened. So could we screen post-employment? Is monitoring an option?
Absolutely, yes. So, but you would choose. So in Europe and elsewhere, you would choose a different ground of processing. So, as I say, pre-employment, some member states in Europe would not, wouldn't smile on using consent, but others will. And so, as I say, some checks you do need to actually get consent. But post-employment, when you're in a employment relationship, you can no longer rely on consent. So what you're looking at is, have I got any other lawful grounds of processing? And the two that normally are relied upon outside of the US are either you've got there's a law that you have to comply with, or a public policy. So that would be your financial services, healthcare, those types of industries. Or you've got a legitimate interest in ensuring that that individual still has a clean background and nothing's occurred. And many organizations now actually do continue to do recurring screenings, either a portion of individuals every single year that are rescreened. And again, that's all about your risk mitigation. It can be built into your policy that you do rescreening. Also, make sure you build that. It's not just about your screening policy at this point. Make sure you build that into your employee handbook and also your employment contracts if you're going to do rescreening and monitoring. But also, so there can be continual monitoring. And we know that a lot of regulated industries do define roles as high-risk roles. Again, going back to that question, who am I screening? What access do they have? And those high-risk roles present obviously a higher risk to the organization. So again, doing recurring monitoring, in particular where you're looking at kind of behavioral type checks like social media, adverse media type checks, credit checks, they can be really insightful and be reviewed by your security teams, for example, to pinpoint any activities that might flag a warning in your system to kind of, do I need to be monitoring this employee a little bit more? So yeah, absolutely, post-employment is fine as well.
Just a few things I wanted to mention from a US standpoint. I see a question from our audience about ban-the-box checks. And that certainly does impact the timing of screening here in the US. So in the US, as a best practice, most employers will wait until after a conditional offer of employment has been extended to an individual in order to request that background check. But that is not a hard and fast rule, with the exception of jurisdictions that have enacted ban-the-box laws or certain jurisdictions that have credit history restrictions. Most jurisdictions that have enacted ban-the-box laws would tell an employer that they cannot conduct a background check until after cannot conduct a criminal check until after a conditional offer of employment has been extended to an individual. And then there are jurisdictions that are even more nuanced. New York City, for example, has really turned things upside down with respect to what a conditional offer of employment is and with respect to when background checks can be requested. In New York City, unlike generally anywhere else, an employer first has to determine that an individual is qualified for the position before extending a conditional offer and then requesting their criminal history. So in New York City, for example, you would whittle your candidate pool down to a certain number of individuals, run them through an initial set of screening that would be everything non-criminal. So, for example, your employment and education verifications, perhaps your professional license verifications, as well as your professional reference questions. All of that would be done, quote unquote, pre-offer. Once you've determined that an individual is qualified for that position, then you would extend the conditional offer, upon which you could then also run their criminal background checks. So again, things in New York City very different from anywhere else. But timing certainly is important in the United States. Post-employment screening is certainly something that is eligible, as well as monitoring. But like I mentioned earlier, you may have to consider additional disclosure and authorization requirements should you intend to run screening post-employment or as part of a monitoring program. Let's keep things moving, Caroline. Let's talk about kind of the separation of duties. Who can request a back? Who should be reviewing the results? What are your thoughts?
So there's a number of, the easier answer is that you would have this all centralized and you would have a team of highly skilled individuals who would be reviewing all the background checks. And that is certainly one option available to anybody. But again, you have to always consistently look backwards to how you started to build your program under your policy. So looking at kind of the types of checks that you are running and where those checks are, where those checks are actually occurring. So where's your hiring location? Because again, just to add on to the multiple layers of complexity that we've talked about here, certain sources restrict, for example, access to the results that they display. So one of the ones that frequently comes up in my area is our Australian criminal results that are accessed via ACIC. Soon to be rebranded a little bit like Prince there. They don't want to be called ACIC anymore. They're going to be called something else. But you can only view those reports if you are based out of Australia. So if you've got a global program, but you hire a lot in Australia, you also need a team that's going to be reviewing those reports out in Australia and also requesting those reports. So it can, you do need to have an awareness as to sort of how those checks actually run. And one of the big things, for example, if you're looking at any EU screening, is you may have a centralized team that you outsource this to, for example, in India or the Philippines, or perhaps maybe, you do it from your HQ in the US. Does that make that more complicated for you because you've got the challenges of all of the data transfer rules and, access to information? So there's lots of things to actually think about in terms of sort of who actually is going to have access to those reports and who's going to initiate. But also then, of course, looking at, once you've figured all of that tapestry out, who should it actually be? Should it be your HR team? Should it be the hiring managers? Should your legal compliance team be involved? And again, I think, one of the things in a policy is to have some form of waterfall, because you will get results. And to the questions that we've had around how do you deal with discrimination, you don't always want to have one single point of decision making. You want to have a matrix where it could be your HR department that administers the entire program, but there may be things you want to flag to a hiring manager to get their input on, for if you're screening a cohort that has a particular skill set that's required, and there may be a discrepancy. Is that impactful or not? The hiring manager is better placed to know that. And if there's a result that's come up where you're really worried about whether or not you actually should hire them, and if you make a no hire decision, would that actually lead to any claims? That's where you get your legal and compliance teams involved. And I know, Alonso, in the US, there's quite a complex tapestry as well in terms of source access and where you might want to, who can request and view results.
Absolutely, and that's exactly what I wanted to touch on, Caroline. Thank you for the lead in there. What we see is many customers, many employers who choose to centralize their background check functions, which I think in general is a very good idea. For those of you who don't know, I come from a financial services background where I helped to run a background check shop for a global company, and that's exactly how we ran our operations. We utilized centralized functions. Again, I think that that's a very good idea, but as Caroline mentioned, in many cases, those centralized functions may be outside of the United States. And what's important for employers to remember is that certain sources do limit access to data outside of the United States. So, for example, with respect to US credit reports, US credit report data can only be reviewed within the United States. So, to the extent that you have an offshore team for the purposes of reviewing your background check results, you would generally have to create a separate function for the purposes of reviewing credit check results within the United States. Similarly, many of you may know that Canada criminal record data, specifically CPIC data, the Central Police Information Center data, this is the Royal Canadian Mounted Police information that's returned, that can only be reviewed within Canada. Subject to certain exclusions. So again, you have to understand your localization rules with respect to those particular issues, develop policy statements as well as process statements that will address how you access that particular information. And like Caroline mentioned, I'm a big believer in an escalation path with respect to how a background check is reviewed within an organization, such that your legal and compliance teams are reviewed with those gray area decisions. I think it's a very important thing. We have about 15 minutes left in today's presentation, so let's keep things moving and talk about data storage. Where will reports be stored and for how long? Caroline, what's your perspective from a non-US perspective?
Yeah, so I think there's often a confusion when we come to this part of a policy between what an underlying employment law says about storing employment related documentation, which is often for a period of 7 years, versus how retention periods actually apply to a background screening report, which is used at an offer usually at an offer stage, and it will be a conditional offer. So not everybody that goes through that process is going to become an employee, either because they fail the check or decide that they don't want the job in any event. So you have to bifurcate in your minds when you're looking at your policies about how you would actually retain data if it was on your own employment files versus how you retain data in a background screening. And massively unhelpfully, our laws aren't as prescriptive as what Alonzo will talk about in terms of data storage and retention under the FCRA. So our laws are very much that you can only keep data for as long as is necessary. So we then have to start looking at what have the regulators said, or the supervisory authorities, what have they said about data that relates to employment and background screening, or data that you gather as part of an interview process where it's not guaranteed that that individual will continue to be your employee. And what the regulators generally say is that once you have used the data for the reasons you've expressed in your information notices, so to help you make a hiring decision, you should then only store that data once that hiring decision has been made for a period. In the UK, it's 6 months at the moment, and in mainland Europe, it's around about 12 months, and the same in APAC. So you generally want to make sure that your accounts that you have, where you're running your background screening, that those reports are actually purged after 6 months or after 12 months. And any of those candidates that you may hire, you've always got the option to download them and keep them on your own HR files, at which point they become subject to your own internal data retention and employee policies, which should align with the local law in that particular jurisdiction. But Alonso, I know the FCRA is much more prescriptive than as long as is necessary.
Yeah, well, it is and it isn't, in that the FCRA does not specifically tell us how long we can retain background check related data. But what we do know, the United States is a very litigious society. And we do know that the statute of limitations, effectively when an individual can bring a claim for a violation, a presumed violation of the Fair Credit Reporting Act is 5 years. So that means that employers will need to retain background check related data for a minimum of 5 years in order to address any potential claims of litigation. I know many of you are going to say there are state laws out there that have differing standards. The issue, though, with those state privacy laws is that they all include an exception for background checks for information gathered in compliance with the Fair Credit Reporting Act. So, because these background checks are FCRA are being processed under the FCRA, the FCRA exemption applies, and a 5-year standard for data retention, minimum 5 years for data retention in the U.S. is what we go by. As we get into our last 10 minutes, let's talk about the process for addressing report discrepancies. Caroline, do you want to kick us off?
Yeah, so this goes back to something that we've both talked about, and I think it's a recurring theme throughout this webinar, which is it's all about being transparent. So if you're dealing with discrepancies with an individual, you have to be transparent and you have to be fair. They're your defenses against any discrimination claim. Now, outside of the US, the critical thing to remember is that as the employer, you are the data controller. And as such, any rights or challenges that may be made in relation to the content of those reports in terms of discrepancies have to be raised directly with yourselves. Now, if you're using a third party such as HireRight to support you with the actual processing of that data and reporting those results, there is obviously a dialogue that occurs between you, your candidate, and HireRight, where, for example, we could rerun a check or provide, based off of extra supporting documentation, or query a source again, and also, of course, update those reports. But the critical thing here is that outside of the US, this is very much led, the conversation with your background screening partner is very much led by yourselves as the data controller, as opposed to the individual having a right to request the information and then ask the background screening provider to make those rectifications or rectify those discrepancies, which is actually in complete contrast to the process in the US, isn't it, Alonzo?
That's exactly right. In the United States, the FCRA prescribes a candidate-led policy. So if a candidate believes that that information in their background report is incomplete or inaccurate, they have a right to dispute that information with the consumer reporting agency, HireRight in this case. And employers, their obligation is to, one, provide a candidate with a pre-adverse action notice that provides them with their rights under the Fair Credit Reporting Act, along with a copy of their report and the opportunity to initiate that dispute to address those discrepancies. They then have to provide a minimum amount of time, which is generally at least 5 business days, in order to initiate that dispute. Notably, though, that if an individual's criminal history is the subject of a dispute, an employer may have to provide additional time to address those particular discrepancies based on that particular jurisdiction statute. So again, your policies will want to consider the local law and bake into your processes the time necessary to address discrepancies in the United States directly with the consumer reporting agency. Let's talk about adverse findings, which I just kind of touched on, Caroline. Talk about adverse findings outside of the United States.
Yeah, so I think the way that you would handle the adverse findings outside of the United States is really driven and governed by not so much a little bit your privacy laws, but really the discrimination laws that we find that support all the employment laws. And Europe in particular is very pro-employee with its employment laws. So you, obviously, as we say, you have to handle all adverse findings fairly. But one of the things that you can do to help yourself with that is to not treat all adverse findings equally. So, for example, if you've got an employment verification and, I'm about 102 years old, I can barely remember yesterday, let alone like 10 years ago. So I might be out by a month or a few days in relation to when I started a job and when I ended a job. That's not a big deal. However, if I'm out by a year or two, I have to ask serious questions of myself, but I might be trying to hide something. If I say I've been in a role for 4 years and it turns out the source says I've only been doing that role for 2 years, that's a bigger difference. So again, you might want to kind of look at what's your tolerance to adverse findings. That's a question to really ask yourself in your policies. So once you've figured out what those tolerances are, is to build an actual matrix, and we call it adjudication effectively, an adjudication matrix that allows you to set a sort of pass versus review process that will actually also help you administer those checks a lot more easily. You won't have to review absolutely everything, but it also allows you to demonstrate that you're handling adverse findings in a fair and transparent manner. And again, not treating them all equally. And I think adjudication is not used so much actually outside of the United States because people do worry so much about discrimination law. So there's a tendency to just review everything. But I do think it can be helpful. But Alonzo, sort of in the US, there's also processes about how you handle adverse findings that are much more stringent, aren't there, than we find in the kind of slightly sort of more principles-based world of the EU or APAC.
Absolutely. In terms especially of criminal history, the process is relatively prescriptive, especially in ban-the-box jurisdictions, which I know our audience has asked about. So you would want to review the specific requirements of that particular jurisdiction. In general, what they tell us is that a criminal history review needs to consider how that individual's criminal history will impact their ability to conduct the role in which they have applied to or are being considered for. And in many cases, the process by which an employer assesses that criminal history is very prescriptive, like Caroline mentioned. There may be specific individualized assessment requirements, specific questions that have to be asked. There may also be specific notices that have to be provided to an individual. All of that has to be done separate from your standard pre-adverse and adverse action processes, which are required by the Fair Credit Reporting Act. At HireRight, you would need to undergo those processes utilizing one of our tools, Compliance Workbench, which is available at no cost to our customers, or separately outside of our platform. So it's really important to understand the nuances of that particular jurisdiction, but at minimum, understand that Fair Credit Reporting Act's pre-adverse and adverse action processes. Separately, I'll quickly mention that several provinces in Canada also have adverse action requirements. So to the extent that you are operating in Canada, you may need to provide an individual with an adverse action notice that describes your disqualification of their candidacy based on their particular background check. So just something important to consider there. Let's start to wrap today with talking about updates to the policy. How often should an employer review and update their policy? Caroline?
So I think same as you would review any other policy. So, you want to do annual reviews, but I think there's some interesting things that you would, really want to focus on when you look at those reviews. So as I say, do it annually. But there are also things that can trigger reviews. So you may have some internal changes within your organization or your sector vertical that would mean that you might want to look at your policy. So you might have had some particular incident that occurs that means that you want to actually go back to that very first question that you asked yourself: is the why? Why am I running a background screening program? Because that reason might change if you have an internal change. And that means that you may then want to re-review the types of products that you actually screen against, or in fact the cohort of folk that you are screening. There could also, of course, be something that happens to one of your competitors that also, is out there in the news that requires you to have another, look to see what's actually occurring within your own policy. Does it still do what it was intended to do in terms of why you're running screening? And of course, as well, you need to make sure that you stay on top of any legal changes. So employment laws are changing all the time. I mean, in the UK, we're just about to go into a general election, and the two main parties have very different views on how employment law should work. And there will be different, very different approaches, which again, there may be changes that need to be made in relation to sort of, whether you can run particular checks or not, or whether they're accepted, or how that might, bake into what we've just been talking about with how you review adverse findings. So there's lots of things to think about in terms of when you would review and update that policy. But the main thing is just keeping on top of everything that's going on externally and internally, and just keep feeding that back into those initial questions that you've asked yourself, because everything else then flows down underneath and will allow you to make those changes. Is there anything else that you want to add, Alonzo?
Well, I think that we'll go ahead and start to wrap, and I'll just kind of provide a summary of what everything that Caroline and I spoke about. So starting with defining the purpose of the background checks, understanding about ensuring the integrity, safety, security of your workforce by verifying the scope of the checks that you're conducting. So qualifications, experience, and suitability of the candidates, for example. Talking about the scope of screening, Carol and I talked about that your policy could apply to all of your prospective employees, your temporary and contract workers, interns, trainees, volunteers, board members, senior executives. You want to focus on who the policy applies to as part of that particular policy statement. The procedures that you're conducting. So think about post-offer, pre-employment, during employment for screening for during employment for specific roles, perhaps upon promotion or role changes. All of this is important to include within your policy. Of course, you'll want to address notice, disclosure, and authorization. Carol and I mentioned how the notice and disclosure and authorization process differs between the United States and outside of the United States. Understand those nuances, include a statement within your policy, and then a process that addresses all of those particular changes. Talk about how you're going to assess criminal convictions, but also other convictions or other items like credit, for example. You want to make sure that adverse findings, including those for criminal convictions, are handled in a fair and transparent manner. Understand that the process, though, differs by who is leading the discussion outside of the US versus in the United States. You want to document your adjudication process, and you want to talk about updating the policy on a regular basis. So we unfortunately do not have time for questions today, but I'd like to thank you so much for joining us today. Caroline, thank you again for your expertise. As always, it's been a pleasure speaking with you. And to our viewers, just a reminder to take 60 seconds out of your day and complete the survey at the end of the webinar. If we didn't get to your question today, we'll get to it after your webinar, but we thank you so much for the interaction. So thanks for joining us, and we look forward to seeing you at a future webinar. Make it a great day, everyone.